We're going to discuss declaratory relief and similar remedies, and this is your Rule 63. Following the syllabus of the Supreme Court, we will be studying first the jurisdiction and the venue. Next is who may file, what are the requisites of an action for declaratory relief, when court may refuse to make judicial declaration, when can you convert a petition for declaratory relief into an ordinary action, and last is the proceedings considered as similar remedies. Ano ba yan? That is your reformation of an instrument, consolidation of ownership, and last is the quieting of title to real property. So let's start with the jurisdiction. Sino ba ang may jurisdiction? Answer is RTC. Take note ha, RTC has exclusive and original jurisdiction. Bakit? Because your subject in a petition for declaratory relief is one that is not capable of pecuniary estimation. Ulit, ang subject sa petition for declaratory relief is one which is not capable of pecuniary estimation. Also, if you're going to read your Section 1, Rule 63, malinaw, ano ang sinasabi dyan? You must bring your action or petition for declaratory relief in the appropriate RTC. Next, venue. Saan ang venue? Answer, general rule on venue applies. So what is the general rule on venue? That is your Rule 4. Ano ang sinasabi ni Rule 4? If it is a real action, you file it where the real property involved or a portion thereof is situated. If it is a personal action, you file it where the plaintiff resides, where the defendant resides, or in the case of a non-resident defendant, where he may be found at the election of the plaintiff. Who may file a petition for declaratory relief? The answer is in your Section 1 of Rule 63. Again, ano ang sinasabi ni Section 1, Rule 63? If you are a person interested under deed, will, contract, or other written instrument, or if you are a person whose rights are affected by a statute, executive order or regulation, ordinance, or any other government regulation, then you can file this petition or action. Take note that the enumeration is exclusive. The enumeration is exclusive. That is only the subject matter in this petition. Also, take note that you can file this petition before breach or violation. Before breach or violation. Again, what did I say in the previous videos? Ano ang sinabi ko? There are some special civil actions which do not have a cause of action. And an example of that is your petition for declaratory relief. Bakit? In your petition for declaratory relief, walang cause of action because there is no breach or violation yet. So meaning to say, there is no violation of the right of the plaintiff. Bar question 1998, a student, he files an action for declaratory relief against his school to determine whether he deserves to graduate with Latin honors. Question, is this action tenable? Answer, no. The action is not tenable. Again, what did we say? Ano ba ang subject matter in a petition for declaratory relief? Very clear, si Section 1, that it must be under a deed, will, contract, or other written instrument, statute, executive order, or regulation, ordinance, or any other government regulation. In our problem, or in the bar question, that is not a proper subject matter. Again, what did we say? The enumeration is exclusive. The enumeration is exclusive. Therefore, if it does not fall within the enumeration, then your petition for declaratory relief is not proper. We'll go now to the requisites of an action for declaratory relief. What are the requisites? Number 1 is, again, the subject matter of the controversy must be a deed, will, contract, or other written instrument, statute, executive order, or regulation, or ordinance. Again, what did we say? The enumeration is exclusive. Number 2, the terms of the documents and the validity thereof are doubtful and they require judicial construction. Number 3 is there must have been no breach of the documents in question. Bakit? Kung meron ng breach of the documents in question, what will happen? An ordinary civil action is the remedy. An ordinary civil action is the remedy and not a petition for declaratory relief. Number 4, there must be an actual justifiable controversy or the ripening seeds of one between persons whose interests are adverse. Number 5 is that the issue must be ripe for judicial determination, and last is not adequate relief is not available through other means or other forms of action or proceeding. Who are the parties to this action for declaratory relief? Answer, all persons who have an interest. All persons who have interest. Section 2, ano ang sinasabi ni Section 2? If you are a person who has an interest or if you are a person who claims an interest and you will be affected by the declaration, then you should be a party to this petition. If you are not a party to this petition or to this action, then the declaration shall not prejudice your rights. Who else? The Solicitor General, si Solgen. Section 3, ano ang sinasabi dyan? If the action involves the validity of a statute, executive order, or regulation, or any other governmental regulation, then the Solgen should be notified. The Solgen is entitled to be heard upon such question. Relate this also to your Rule 3, Section 22. Ano ang sinasabi ni Rule 3, Section 22? If the action involves the validity of any treaty, law, ordinance, executive order, presidential decree, rules, or regulations, the court has the discretion to require the appearance of the Solgen who may be heard in person or a representative duly designated by him. Sino pa? Your prosecutor or attorney of the LGU. Kailan papasok si prosecutor or attorney of the LGU? Ano ang sinasabi ni Section 4? If the action involves the validity of a local government ordinance, then the prosecutor or attorney of the LGU should be notified and entitled to be heard. Kailan naman papasok si Solgen? Papasok si Solgen if the ordinance is alleged to be unconstitutional. Then the Solgen should be notified and entitled to be heard. Question. Can the court refuse to make judicial declaration? Answer, yes. The court may refuse to exercise the power to declare rights and to construe instruments. Please take note that this power of the court may be exercised on its own or motu proprio or upon motion. So again, what are those instances wherein the court may refuse to exercise this power? Number 1 is if the court feels that even if there is a decision, still it would not terminate the uncertainty or controversy which gave rise to the action. Second, if the declaration or construction is not necessary and proper under the circumstances. But this power of the court to refuse to make judicial declaration does not apply where the actions involved are the following: action for the reformation of an instrument, action to quiet title, and action to consolidate ownership. This is your Section 5. 2012 Bar Question number 21 MCQ. In a declaratory relief action, the court may refuse to exercise its power to declare rights and construe instruments in what instances? Choices are: letter A, when a decision would not terminate the controversy which gave rise to the action. Letter B is in an action to consolidate ownership. Letter C is to establish legitimate filiation and determine hereditary rights. Letter D is A and C above. So again, ano ang sinasabi ni Section 5? Section 5 reads that the court may refuse to exercise the power to declare rights and to construe instruments in any case if sa tingin niya that even if there is a decision, still it would not terminate the uncertainty or controversy which gave rise to the action. And the correct answer here is letter A. Can you convert an action or a petition for declaratory relief into an ordinary action? Answer, yes. It may be converted into an ordinary action if before the final termination of the case, there is a breach or a violation. Before the final termination of the case, there is a breach or violation. And in that case, when this happens, the parties will be allowed to file pleadings as may be necessary or proper under your Section 6. We'll go now to the proceedings considered as similar remedies. We start with the reformation of an instrument. So what is our civil or substantive law that can be found in our Civil Code of the Philippines? And our Rule 63 is of course our procedural law. So ano ang sinasabi ni Civil Code? When the true intention of the parties to a perfected and valid contract are not expressed in the instrument purporting to embody their agreement because of mistake, fraud, inequitable conduct, or accident, one of the parties may ask for the reformation of the instrument. What is the purpose? So that the true intention may be expressed. Please take note that in a reformation of the instrument, there must be a perfected and valid contract. Take note of that, ha? There must be a perfected and valid contract. And what is our applicable article? That is Article 1359. So this is our substantive law. Ano ang sinasabi ni Article 1359? When there having been a meeting of the minds of the parties to a contract, their true intention is not expressed in the instrument purporting to embody the agreement by reason of mistake, fraud, inequitable conduct, or accident, one of the parties may ask for the reformation of the instrument to the end that such true intention may be expressed. So what are the requisites for this action? First is there must be a meeting of the minds of the parties. Second, their true intention is not expressed in the instrument, and the failure to express their true intention is due to mistake, fraud, inequitable conduct, or accident. Please take note that pag pinag-uusapan si reformation of an instrument, it presupposes that there is a perfectly valid contract. Kaya sinabi ko kanina na please take note of a perfected and valid contract, meaning to say there has already been a meeting of the minds of the contracting parties. Bakit? Pag walang meeting of the minds, the proper action is not a reformation of an instrument but an annulment of a contract. Annulment of a contract if there has been no meeting of the minds because the consent of the one of the contracting parties has been vitiated. Our basis is Article 1359, second paragraph. Let's read ano ang sinasabi dyan. If there has been a mistake, a fraud, inequitable conduct, or accident has prevented the meeting of the minds of the party, the proper remedy is not the reformation of the instrument but an annulment of the contract. To understand better the concept of reformation of an instrument, let's take a look at this bar question. On June 13, 1982, the seller here sold to buyer in a public instrument a parcel of land for 50,000 pesos. Simultaneously, on the same date, the buyer granted the seller an option to buy the same property for 50,000 pesos within 1 year. But on June 13, 1983, the buyer allowed an extension of the option to buy for another year, but the price is no longer 50,000 but 72,000. All the while, the seller remained in possession of the land. In May 1984, the seller filed an action for the reformation of the deed of sale into a real estate mortgage, alleging that the land covered thereby was given only as a security for the repayment of the loan. Question: will the action prevail? Answer: yes, the action will prevail. Because what really is the transaction between the buyer and the seller is a loan and not a sale. Ano ang mga indications that the transaction really between the parties is a loan and not a sale? First is the seller remained in possession of the premises. The seller remained in possession of the premises. Second, he was given that option to buy the same property on the same day that the deed of sale was executed. And the last indication is the repurchase price increased at a rate of 20% 20% a year, which could be an equivalent to an interest at the rate of 20% a year. And ano ang sinasabi ni Article 1603? In case of doubt, if there is a contract purporting to be a sale with right of repurchase, it shall be construed as an equitable mortgage. Therefore, the instrument should be reformed. Another bar question which was asked in 2016, similar lang doon sa binasa natin kanina. Here, the seller entered into a deed of absolute sale wherein he sold his titled lot in Quezon City with an area of 300 square meters to the buyer, Noel, for the price of 300,000 pesos. But the prevailing market value of the lot is actually 3,000 pesos per square meter. They also executed another agreement, which is an agreement to buy back or redeem the property, where the seller was given an option to repurchase the property. The seller remained in actual possession of the lot, and it was also the seller who paid the real property taxes because the buyer did not pay. On March 21, 2010, Ariel, or the seller, sent a letter to the buyer attaching a manager's check manifesting that he is redeeming the property. The buyer now is rejecting the redemption, claiming that the deed of absolute sale was a true and valid sale representing the true intent of the parties. Therefore, the seller now files a suit for the nullification of the deed of absolute sale or the reformation of the agreement to that of a loan with REM. He claims that the deed of absolute sale and the redemption agreement constitute an equitable mortgage. The buyer, however, claims that it is a valid sale with pacto de retro, and Ariel clearly failed to redeem the property. So as the RTC judge, you decide the case with reasons. So as a judge, how will you rule? You will rule in favor of the seller or in favor of Ariel, because clearly what we have here is not a deed of absolute sale. The transaction between the buyer and seller is really an equitable mortgage. Ano ba ang mga indications that it is an equitable mortgage? First, the price of the lot was inadequate. Second, the vendor or the seller remained in actual possession of the property. And third is the seller was the one who paid the real property taxes. Again, ano ang sinasabi ni 1603? If there is a contract purporting to be a sale with right of repurchase and then there is a doubt, it shall be construed as an equitable mortgage. Therefore, the reformation of the agreement is proper. What is the basis? The basis is the principle of equity. And what is the nature of this action for reformation of an instrument? It is actually a limitation or an invasion of the parole evidence rule. Bakit? Because when you allow the instrument to be reformed, what will be the result? The oral agreement is made by the court legally effective. Again, balikan natin. Ano ang sinasabi ng parole evidence rule? Parole without an E, ha? Parole without an E. According to your Rule 130, Section 10, when the terms of an agreement have been reduced into writing, it is considered as containing all the terms agreed upon. And there can be no evidence of such terms other than the contents of the written agreement. However, a party is allowed to present evidence to modify, explain, or add to the terms of the written agreement only if he or she puts it in issue. And the requirement now, according to the amended rules, is it must be in a verified pleading. So if you are going to put in issue that the agreement failed to express the true intent and agreement of the parties, then you are allowed to present evidence. But please take note, ano ang sinasabi ng mga jurisprudence? The court, as the agencies authorized by law to exercise the power to reform an instrument, must exercise this power sparingly and with great caution and zealous care. What are the instances where the remedy of reformation of instrument is proper according to Article 1361? If there is a mutual mistake of the parties and it causes the failure of the instrument to disclose the real agreement, then the instrument may be reformed. Article 1362, one party was mistaken and the other acted fraudulently in such a way that the instrument does not show their true intention, then you can also ask for the reformation of an instrument. Article 1363, one party was mistaken and the other knew or believed that the instrument did not state the real agreement, but he concealed that fact from the former, then you can also ask for the reformation of an instrument. Article 1364, there is the ignorance, lack of skill, negligence, or bad faith on the part of the person drafting the instrument or on the part of the clerk or typist, and the instrument does not express the true intention of the parties, then the court is allowed to order that the instrument be reformed. And your Article 1365, ito ang palaging tinatanong sa bar exams, if there are two parties, they agree upon the mortgage or pledge of real or personal property, but the instrument states that the property is sold absolutely or with a right of repurchase, then the reformation of the instrument is proper. Ang tanong, who will ask for the reformation of the instrument? In Article 1361, it can be either party because that is a mutual mistake of the party. So, either party or the successor in interest. For your Articles 1362 to 1365, the person who can ask for the reformation of the instrument is your injured party, the heirs, or assigns. So this is your Article 1368. Ano ang sinasabi ni Article 1368? Again, reformation may be ordered at the instance of either party or his successor in interest if the mistake was mutual, otherwise upon petition of the injured party or his assigns and heirs. What instruments cannot be reformed? Answer can be found in your Article 1366. Ano ang sinasabi ni Article 1366? In simple donations inter vivos wherein no condition is imposed, if it is a will or the real agreement is void, then you do not allow the reformation. We'll go now to consolidation of ownership, but before we start our discussion, let us take a look at this deed of sale under pacto de retro. Ano ba ang nangyayari pag ang agreement is a deed of sale under pacto de retro? The vendor or the seller has the right to repurchase. The buyer or the vendee has the obligation to resell. But what happens if the seller fails to exercise his right to repurchase within the period stipulated? Then the conveyance becomes absolute and irrevocable, and without the necessity of drawing up a new deed of absolute sale, subject to the requirements of the law regarding consolidation of ownership of real property. Your consolidation of ownership under Rule 63 is your procedural law, and what is our substantive law? That is the Civil Code, particularly Article 1607. Ano ang sinasabi na Article 1607? In case of real property, you allow the consolidation of ownership in the vendee only if the vendor fails to comply with Article 1616, and it shall not be recorded in the registry of property without a judicial order after the vendor has been duly heard. Without a judicial order after the vendor has been duly heard. Ano ang sinasabi ni Article 1616? The vendor has the obligation to return to the vendee not only the price of the sale but also the expenses of the contract, any other legitimate payments, necessary expenses, useful expenses made on the thing sold. Bakit necessary ang consolidation of ownership? Why is it necessary? Because the reason for that is the transaction may not be a genuine pacto de retro but only an equitable mortgage. The reason is that the transaction may not be a genuine pacto de retro but only an equitable mortgage. That is the reason why there must be a judicial order. The vendor must be heard. Before kasi, ang process ng consolidation of ownership is you file only an extrajudicial affidavit and there can be now a consolidation of ownership. But now, there must be a judicial order. There must be a judicial order. The purpose for that is it provides additional safeguards to the debtors. Down to our last topic, which is the quieting of title to real property. So what are the requisites? Number one, the plaintiff must have a legal title or an equitable title or interest in the real property, which is the subject matter of the action. This is your Article 477 of the Civil Code. Again, the plaintiff must have legal or equitable title or interest in the real property, which is the subject matter of the action. Number two, there must be a cloud on such title. Number three, the cloud is due to some instrument, record, claim, encumbrance, or proceeding which is apparently valid or effective but in truth and in fact invalid, ineffective, voidable, or unenforceable and is prejudicial to the plaintiff's title. This is your Article 476. Ano ang sinasabi ni Article 476? If there is a cloud on title to real property or any interest, and the reason for that is there is this instrument, record, claim, encumbrance, or proceeding which is apparently valid or effective but is in truth and in fact invalid, ineffective, voidable, or unenforceable and may be prejudicial to the title, the action may be brought to remove such cloud or to quiet the title. And the last requisite is that the plaintiff must return to the defendant all the benefits he may have received from the latter or reimbursed him for the expenses that may have redounded to his benefit. This is your Article 479 of the Civil Code. Let's go back to this Article 477 and important requisites. The plaintiff must have legal or equitable title. What is the meaning of that legal title? Ang ibig sabihin niyan is the legal title denotes registered ownership. How about an equitable title? What is the meaning of that? It denotes beneficial ownership, meaning to say the title of the person was derived through a valid contract or relation and that person has that right to have the legal title transferred to him. Also, take note na pag pinag-uusapan si quieting of title, the subject matter here is the title sought to have quieted. And your title is not limited to the certificate of registration under the torrent system. Kasi ano nga ang sinasabi again ni Article 477? You can have a legal title or a registered ownership or an equitable title or beneficial ownership. And what is again the requirement? You need not even be in possession of the property. It is very different from your declaratory relief kasi sa declaratory relief, the subject matter is not your title but the deed, will, contract, or other written instrument, and the issue is the validity or the construction of the documents. Take note that in an action for quieting of title, the court really has the task to determine the rights of the complainant and other claimants. Bakit? So that he who has the right would see every cloud of doubt over the property dissipated. And when there is now a quieting of title or the title is quieted, he could afterwards without fear introduce the improvements he may desire to use and even to abuse the property as he deems best. Let's read this 2011 Bar Question MCQ. Which of the following is an indispensable requirement in an action for quieting of title involving real property? The plaintiff must, letter A, be in actual possession of the property, or the plaintiff must be the registered owner of the property. Letter C is the plaintiff must have legal or equitable title to the property. And last is that the plaintiff must be the beneficial owner of the property. Again, ano ang sinasabi ni Article 477? The plaintiff can have a legal title or he can have an equitable title or interest in the real property which is the subject matter of the action. He need not be in possession of said property. So the correct answer here is letter C. The plaintiff must have legal title or equitable title to the property. To summarize what we have discussed, your Section 1 answers the question of who may file a petition for declaratory relief. Section 2, Section 3, and Section 4 are the parties to this action. Section 5 is when court may refuse to make judicial declaration, and your Section 6 is when can you convert this petition for declaratory relief into an ordinary action. Take note that the subject matter in a declaratory relief is exclusive, and the issue here is the validity or the construction of the documents, and the relief sought is the declaration of the petitioner's rights and duties. As far as the similar remedies are concerned, ano ulit ang similar remedies? That is the reformation of an instrument, the consolidation of ownership, or the quieting of title to real property. The reason why they are considered as similar remedies or similar to declaratory relief because the result in this similar remedies is also the same result in your declaratory relief. There is an adjudication of legal rights of the litigants, but often without the need of execution to carry the judgment into effect. So this is the end of the video. Thank you very much for watching.